wherever you are. I'm in New York City. Some of you are in Australia. Some of you are in Nepal. Some of you are in India. Some maybe in Europe. So we are all over, but the marvel of technology makes it possible for us to meet and talk today on a very important topic, which is the human rights impact of COVID-19 technologies and what is the role of business. Businesses have a major role to play, both in terms of dissemination of information, in weeding out untruths from truth, as we will discover shortly, and also in trying to make sure that businesses are also protecting the privacy of those who use the technologies that are meant to enable and assist the state to ensure that the right to health is protected. So lots of fascinating topics which are part of this. We have a distinguished panel. I'll introduce them in a moment. But before I do so, we have a short intervention, about 10 or 15 minutes, in which I have a conversation with Irene Khan, the Special Rapporteur for the Right to Information and Right to Free Expression. She lives in Geneva. Given the time involved, it would be in the middle of the night for her. So we chose to record the conversation. So I request Rohini to play the conversation first, and then I'll revert to our conversation as we have planned with my three very distinguished, very qualified panelists. Thank you. Rohini, over to you. Rohini, I can't hear the voice. I hope everybody else can hear it.
Rohini, when you share screen, please click share sound as well. Can you do it?
Hello, everybody. This is Salil Tripathi. I'm the Senior Advisor for Global Issues at the Institute for Human Rights and Business. And I'll be walking us through this session about surveillance and tracing and tracking and what it means in the new world in which we are thanks to the pandemic. We have divided the session in two parts. In the first part, I'm going to have a conversation with Irene Khan, who is a Special Rapporteur for Freedom of Expression and Information at the UN. And earlier, she has been with IDLO, which is an international development law organization, which she ran with great distinction. And prior to that, she was the Secretary General at Amnesty International, and before that, at the UN High Commission for Refugees. And we will talk through some of these issues. And after we have concluded that discussion, we will join other panelists and discuss and drill and dig deeper into this issue. So first of all, thanks very much, Irene, for joining us today.
Thank you very much for inviting me.
Thank you very much, yes. My first question is, we want to talk about the technology platform that governs so much of our life today. Do they have too much power in deciding what can and cannot be said about the pandemic? Because, all the laws about fake news and what can, today we know that Facebook and YouTube and Google can take away content that they think is undermining science. And are they justified in removing the content?
Well, platforms, as we all know, is a major means, if not the major means, by which we communicate with each other today. So how much content moderation should be there? I think there is an ambivalence about it among ourselves. Too much, and the platforms stifle free speech. Too little, and they facilitate disinformation, misinformation, online violence against women, for example. And then you have a third element, and that is the state influence or interference with what goes through the platforms. So I think the concept of freedom of information on the platform is a myth. User control is a myth. There is considerable content curation that takes place, content moderation that takes place, perhaps even content manipulation that takes place, thanks to the ad-driven business model that tries to keep us engaged on platforms. And therefore, that raises, how do you balance control and moderation against our ability to communicate freely? And I think the key issue, there are a couple of key issues that we need to focus on, rather than looking at whether too little or too much. One is transparency. What is actually happening? How is the information being manipulated? How is our own access to information being controlled? And second are, what standards are the platforms using to moderate content? Very often, as private companies, they have their own rules. And the message that has come from my mandate, for example, the work of my predecessor, David Kay, and now myself, is companies must use human rights standards when they look at content moderation. And when and I say that because what we're talking about is a public space, public service provided by private actors. Therefore, they need to follow their obligation to respect human rights when they do content moderation, and transparency and accountability is part of that. And they must ensure, of course, remedies for individuals whose post may, for example, be removed, so that people know what has happened and people can then appeal it.
Right. Now, you raised this issue of human rights standard, which is very important for the next question that I'm coming to, that one of the things that has come about, thanks to the spread of the pandemic, is surveillance. People want to know who may be infected and where they are going and who they are meeting. Human rights law is, of course, derogable, which means there are parts of it which can be suspended at certain times. So is surveillance ever justified under human rights law?
Well, surveillance has huge impact on several rights: right to privacy, freedom of expression, peaceful assembly, family life, even right to health. In the COVID-19 context, we've seen that. And technology means that surveillance is no longer limited by space or duration. So it's a very risky world in which we are living. International law does not allow surveillance without oversight, without limit, without safeguards. It recognizes that surveillance may be necessary, for example, for crime detection, for public health monitoring now, as we've seen, or even for intelligence gathering for national security purposes. But there has to be some limits on it. And so it cannot be, surveillance cannot be arbitrary or unlawful. And the principles that have been laid down is of legality, necessity, and proportionality. That it must be lawful under international law, not simply national law. It must have a legitimate aim, and it must be proportionate and necessary to achieve that legitimate aim, whether it is public health or national security or public order. And therefore, it means that it has to be subject at some point to judicial scrutiny. There must be some rules set out clearly that bind the state to it. And what the state does has to be proportionate. I mean, you cannot have mass surveillance and use that data for all sorts of purposes. So those are the sort of what I would call guardrails that international law puts on states.
Yeah, and I suppose the proportionality also includes time-bound nature and region-bound nature, because that's where it becomes problematic. Now, if we have to use technology to trace and track people, what are the human rights implications of that on individuals? What happens if the person is identified as having been infected? What should the state do? Does it mean that his or her freedoms are immediately curtailed?
Well, I think, first of all, the state has to ensure some degree of data protection. You know, if the person is infected, then who needs to know? And what does the individual need to know? So there is the issue of data protection. It becomes very important. Secondly, protecting the individual against discrimination. We've seen that, for example, in the case of HIV/AIDS, that information can be misused. So the state needs to protect the individual's rights and needs to use that information only to the extent that it is necessary in order to protect public health or the rights and lives of other people. So that there needs to be a restrictive approach to it, not an expansive approach.
Mm-hmm. Now, in terms of freedom of expression, have you seen substantive erosion of that right due to surveillance, particularly in the times of COVID? What I have in mind is, journalists and human rights defenders who have been, obviously targeted to a substantial degree, who speak of privacy being singled out of silence, or who speak for the rights of the infected and who are singled out. And what kind of trends have you seen in the last few months?
Well, we've seen attacks on journalists primarily because they are putting out in the public domain information that challenges governments. To some extent, I think in the COVID-19 era, we've actually seen governments as producers of misinformation and disinformation. So there's, of course, a reaction from governments when journalists challenge them. There is, of course, also we've seen in two ways. One is direct attack on journalists, where people are being arrested, thrown into prison, and so on. But there is also a chilling effect that takes place because there's so much of surveillance. We've seen at a time when COVID-19 really didn't understand what's happening, we've actually seen the information space, legislation being used by governments to stop information going out into the public domain that could challenge what they are saying. Or at the same time, we've seen a proliferation of misinformation also by private actors, hucksters, and others trying to sell medicine or trying to put out false information, the anti-vaxxers, for example. So there has been a huge proliferation, a huge business of misinformation and disinformation that has grown, in which journalists have come under attack from all sides for trying to put out information. Now, what we have found, my report on disinformation to the Human Rights Council emphasizes that the best antidote of misinformation and disinformation is actually diverse, multiple sources of information, including public information, as well as independent information crisis in the middle of the pandemic.
Yes, how can truth try to struggle out of, and it applies way beyond the pandemic. I mean, we see it also in the context of the political spheres. The next question I have goes back to what we were speaking about earlier, the necessity and proportionality issue that you spoke about, that one of the problems measures invoke suspend human. It's hard to get rid of those provisions. We know that from 9/11 when we were colleagues at Amnesty, and I remember very well. You were warning us that these things will get codified into hard law. So can there be sunset clauses that can be built to stop the use of such technologies when they're no longer needed, or do you believe that technology, once it is there, people will think of newer uses of it, and are we in a kind of new normal which is beyond what we can predict?
Well, stopping technology is a little bit like King Canute asking the waves to stop, because innovation will continue and there will be other types of spin-offs from the technology that has been created. But there is a responsibility on the state to regulate not by innovation, but by ensuring that innovation does not erode human rights. And I think that is where the challenge is going to be. Now, international human rights law, as you know, actually recognizes that in a state of emergency, for example, whether it's a public health emergency or if it's another kind of emergency, certain human rights can be suspended. But the suspension is for a clear, limited period of time, and there is some scrutiny on the way what happens. And when that time period is over, situation goes back to normal again. That is the theory of it. In practice, of course, governments, once they have the power, very rarely want to give it up. That actually makes the role of journalists, the role of civil society, the role of human rights defenders.
I think we have lost the sound of the video. I'm thinking if Salil can continue to share.
Okay, I'll try sharing, but
If you want me to,
if you could do it, because what minute are we on? I'm not exactly sure what time slot we are at the moment. Yeah. Can you do it?
Just give me
Yeah, sure.
15 seconds. Let me try.
We have to vigilant
Can you stop sharing, Rohini? And let me know how many minutes.
I've got my quick time on, so I can do it if you want me to. If you can tell me where to start, yeah.
Yeah, where to start? Rohini, can you tell us? Rohini, are you here?
For example, COVID-19, I'm positive. I don't have a duty to tell you. However, you do have remedies under national law.
Oh, shit. This is at the end
of
the
video. You can sue me. You can, and that happens all the time. For example, in defamation cases, it can happen in other ways in which I infect you. There is jurisprudence there. So it's the national system under which that protection of your right can be enforced. And if then I would disclose. So it becomes, what we're talking here, you have the legal issue. Now, how many individuals are going to go?
I think that is where the challenge is. International human rights law, as you know, actually recognizes that in a state of emergency, for example, whether it's a public health emergency or another kind of emergency, that can be
Rohini, can you stop yours? I think I'm able to share mine.
For each other. And that sense of needs, it's a question of solidarity.
This is somebody's, this was being played back from somebody's mic. I don't know why.
Okay, I think I have forcefully stopped it. Sorry, can you tell me how many minutes?
Okay,
are you sharing?
I think I'm starting at the 11th minute. We have 4 minutes left, so let me start with that. Let me see if this works.
Okay.
The suspension is for a clear, limited period of time, and there is some scrutiny on the way what happens. And when that time period is over, a situation goes back to normal again. That is the theory of it. In practice, of course, governments, once they have the power, very rarely want to give it up. That actually makes the role of journalists, the role of civil society, the role of human rights defenders extremely important. We have to be vigilant and we have to keep pressing to ensure that governments do not see this as an excuse to jettison human rights.
Right. And my final question actually is again a leap in the dark. I mean, I know nothing about it, but you can help me think it through. And which is what happens when we move from the public sphere to the private sphere. I live in New York, and if I go to a restaurant, this morning I was at a coffee shop and I went there and I had to show my vaccine card in order to enter the shop, although I was wearing a mask. And of course, I've been vaccinated and so on. But my question is, a business has a right to ask that of me because the state gives it that right. What happens with individuals? One of the reasons is that one of the reasons for the surveillance is to isolate those who are infected by the virus. Do healthy individuals have a right to know, as part of the right of information, about who they are meeting and what that might mean to them? What happens when two individuals meet? Is there a need for protocol?
It's a very
decency and courtesy, yeah.
Yeah, no, it's a very interesting question to raise, because human rights is actually about the obligation of states or the obligations of companies, large entities, against to ensure the right of the individual. Now, what you're talking about, is there a duty of one individual towards another under international human rights regime? And this has been a big debate that has gone back into, in the Soviet days, socialist versus capitalist countries. If you have a right, I don't have a duty to tell you what, if I am in some way, if I have, for example, COVID-19, if I'm positive, I don't have a duty to tell you. However, you do have remedies under national law. I mean, if I were to hurt you or damage you in some way, you can sue me. You can, and that happens all the time. For example, in defamation cases, it can happen in other ways in which if I infect you, there is jurisprudence there. So it's the national system under which that protection of your right can be enforced. And if I'm going to be careful, if I don't want to be sued, then I would disclose. So it becomes, what we're talking here, you have the legal issue. Now, how many individuals are going to go sue other individuals. That's a difficult thing. What we're really talking about is kind of social protocol and our obligation, our sense of duty as good citizens, as good members of the community to care for each other. And that sense of community needs, it's a question of solidarity there rather than of law.
That's a fascinating note to end on, because I think that's exactly one of the problems of the fraying social fabric in the world, where everything is us against them, those who are for vaccine, then those who are not for vaccine, those who like to live in a world with lot people from all parts of the world, and those who want to isolate and live in a bunker, and it's going to be very complicated. And the pandemic, of course, upends everything as we have known it. So you've given us a lot of food for thought, and we will have further discussion as we go along today. Thank you very much.
Thank you.
Okay, sorry about the glitches, and I hope you were able to get the bulk and the gist of it. We do have the video, which of course can be shared, and the forum will have it with them, and they will probably put it up on the YouTube or whichever other format in which they are going to make it public. So you will be able to see it again subsequently. So, but my apologies, the organizers' apologies, everyone's apologies for that it wasn't as smooth as we thought it would be, but it's a miracle that we are still able to meet in different parts of the world to have this very important conversation. Yes, I just see the note from Christine that yes, the original video will be uploaded on the website. So those of you who missed part of the conversation in the middle part will be able to access it later. But now to turn to my very, very distinguished panel. I've got Graham Greenleaf all the way from Sydney, who teaches privacy law. He's an expert on privacy, internet issues, and human rights. And he's going to talk us through some of his concerns about what is the role of the state, what is the role of the corporation. We have Manisha Dogra, who is based in Singapore. Right now, she's not in Singapore, but she will be there soon. And she is going to speak about representing as a director of sustainability in a very dynamic region, Asia Pacific, for Telenor, the company from Norway, which has operations in several countries in the Asia Pacific region, providing connectivity, which is so vital for right to information, right to free expression, and right to knowledge about where we are and where we're going. And finally, we have Rohini Lakshane, who is an independent researcher based out of India. She has, actually, she and I collaborated quite closely on a report that we are publishing later in the year on investigating and exploring apps from 11 countries which trace and track individuals using phone-based systems, try to figure out who is infected and who's not, and what the state should do about it. But as with all these systems, excellent on paper, but lots of questions that are raised. So I'm going to turn to each of the participants, and first, very quickly, if you have any burning thoughts that emerge from what Irene said. I know you had the advantage of having probably seen the video before it appeared, so you didn't have this disjointed version, but if you have any immediate reaction to what Irene said, let's take to that. Otherwise, I'll start with you, Graham, regardless for your presentation, but do let me know if anyone would like to react to any of her points.
Yes, thank you, Salil. I will just share my PowerPoints, which will make my presentation
Let's do that.
somewhat easier to follow.
Let's do that. Yeah, thank you.
Is that working now? You can see them,
Yes.
can you?
Yes, we can see it very clearly. Thank you.
Great. Yes, well, this is a product of some work I've been doing with a colleague, Dr. Catherine Kemp. And the starting point here is that as the COVID-19 pandemic develops and responses to its control develop, forms of COVID data surveillance are multiplying. And I've listed a number of them there that are operating in Australia at present, or just about to operate, and the different technologies that they employ. So COVID surveillance, as I'd call it, is changing rapidly. But all of these examples of COVID surveillance are the sort of emergency measures involving the suspension of normal civil liberties that we're used to. But as Irene was suggesting, these emergency measures do not mean that all human rights protections are to be abandoned. In fact, the gist of our argument is that if you have the suspension of normal civil liberties and human rights, you have to have increased legal protections, not the abandonment of them. And what we'd suggest is that there are legislative protections which can be based on common principles for all types of COVID surveillance. And that's the sort of legislation that we need to see being adopted by countries around the world as the COVID surveillance mechanisms change. And I'll mention two in particular. One is the COVID Safe Act in Australia, which was designed to regulate proximity tracking using Bluetooth, and the EU's COVID status certificates. Now, there are two very desirable protective principles, but often in these particular circumstances of COVID-19, it's almost impossible to get governments to agree to them. The first is that there be voluntary measures with no compulsion. And the second is that there be no central database accumulating data, that should be avoided wherever possible. But what we'd say is that even if you can't achieve those two desirable protections, other protections are possible. And in this set of slides, we've given some details of 10 different protections that ought to be available for all types of COVID surveillance. And in the time available, I'll only be able to mention a few of those. The first, we think, is to put the controls, the legislative controls, within the jurisdiction's existing data privacy law, because these protections build on top of the normal data privacy law protections. And that occurred in Australia with its COVID Safe Act, which is in fact Part 8A of our Privacy Act. Second principle is that wherever possible, guarantees should be added to avoid unjustifiable discrimination against particular sets of people. So, for example, with the EU's digital COVID certificates, 100 million euros was provided by the EU to subsidise European states in providing affordable COVID testing. A further principle is to define, legislation should define the authorised uses of what we can call COVID data. And in the Australian example, all uses of COVID app data are illegal, involving potential 5-year jail sentence, unless explicitly permitted by the legislation. And the legislation basically says you can use this data for contact tracing and nothing else whatsoever. And that principle is backed up by further anti-coercion provisions, which are not aimed directly at the COVID app data, but rather making it an offence to require people to download the app or to present their phone and show that they have the app installed, or to be limited in getting some benefit unless they can show the app has been installed. So just about every possible use of the COVID Safe app that could be used to coerce people to be involved in that system was included in the legislation. I'll just mention a couple of other of these principles. This one, an ongoing deletion program, is because, as Irene said, surveillance systems are very rarely undone once they're developed. But one thing you can do in setting up a system is require the ongoing deletion of data immediately it is stopped being of use. So in the Australian case, logs were, on the COVID Safe app, logs were automatically deleted from phones after 21 days. And with QR code tracking in Australia, most of our states require deletion of data after 28 days. But also, as Irene mentioned, a desirable quality is to have a legislated sunset clause for the whole system. And in the Australian legislation, there is a provision that the responsible minister has to declare when the COVID Safe app is no longer required or effective to limit surveillance. And at that point, all aspects of the central database have to be destroyed, including all app data. Another method of sunset clauses is in the EU's digital certificates, where the regulation that's legally established them will simply cease to apply after 30 June next year, unless it's renewed by European law. So all of those things are valuable. And finally, Irene mentioned the importance of transparency. And where systems are developed which clearly do pose long-term dangers to our human rights, it's necessary that they be as transparent as possible. So in the COVID Safe app case, the source code for the app was eventually released for the individual phone part of the source code, but other aspects were not very transparent. At any rate, I hope I've now given you an idea of the sort of things that can be legislatively introduced in relation to all types of COVID surveillance. Thank you.
Sorry, I'm unmuting myself. Yeah, no, it's fascinating what you pointed out, and I think it's good to see that some of the safeguards of the kind that civil society and privacy experts would want are being reflected, but it's wise to be cautious as always. Now I want to turn to Manisha. Manisha, you represent a company, and Manisha, you have to deal with regulations that come from governments on one hand, and you also have to deal with expectations of civil society, which might be at the opposite extreme. And you also you represent a company which is from a rather unique country, Norway, which is a very strong policy on human rights. And there's a joke in the human rights community that Norway is an NGO that happens to have passport controls, that it's only a country in name. Actually, it's an NGO. But be that as it may, that's a great compliment, but it's still a country. That still has to govern, it still has to have rules. So tell us how it is done as a Norwegian company in a country in countries with different setups and different rules, and operating in a climate of a crisis of human rights, which affects everybody.
Thanks, Salil, both for the introduction, but also for inviting me to join this interesting discussion. And apologies to all the participants if you get background noise from me. I'm in a vibrant community in India right now, and it's morning, so things are moving along. But to your point, Salil, being a Norwegian company operating both in the Nordics, but having a vast footprint in Asia, covering South and Southeast Asia, does definitely put Telenor in a unique position. And the way that we have kind of dealt with both handling business and human rights issues before COVID, but more importantly, in the past 2 years, with topics and issues coming up related to COVID, has been to use the international human rights framework and, more importantly, the UN guiding principles as our guiding stars. Our internal policies of human rights assessments, of data privacy impact assessments, etc., are all rooted in these international principles and frameworks, and they are applicable globally.
If I can interfere for just one moment, because we have a very tech-savvy crowd, but because UN guiding principles may not be widely known, these are UN standards which call for 3 things. The state has a responsibility to protect rights, companies have a responsibility to respect rights, and when there are gaps, there needs to be a remedy. Please go on.
Thank you so much for that clarification, Sahil. So what we have then done, having this vast footprint, and as you said, that not all of the countries that we operate in have the same governance norms, the same legislative structures, but more importantly, and especially from a COVID context, also not the same public and regulatory or authority awareness on human rights as well as privacy rights and issues. So what we have kind of used throughout this process is to have our internal processes and protocols based on these international frameworks. Telenor is also, as you know, and for the participants, a member of a multi-stakeholder initiative called the Global Network Initiative, which has certain clear principles. So we have protocols of handling any requests or directives from the authorities in a rights-based way. And as Ms. Khan alluded to, the basic fundamental of assessing any request that we receive from an authority, whether it is for content moderation or, more importantly, what we as a telco received since the start of the pandemic, was more access to mobile data. And what we did was, first and foremost, as early as end January last year, was to remind all our internal resources and companies that even though this is a health crisis and there is the derogation clause and there can be the Syracuse principle, they need to assess each request coming through using the same framework, which is to assess the request on legality, necessity, and proportionality. If these things were not met with, to engage in a dialogue with the health authorities or the telco regulator, which is usually where we get our requests. And we found that the type of requests coming our way, as well as the understanding of how a telco can support COVID prevention and tracing, varied dramatically across the countries. So we took the opportunity of actually importing or knowledge and awareness from our Nordic countries and what was happening there to some of our Asian countries and regulators, but also re-emphasize that even though this was a health crisis, the basic fundamentals of assessing a request, documenting it, making sure that there was transparency around it did not change. And that, I think, helped us both support the authorities in their efforts, which were all for good reason, but also weed out some of the overbroad requests that were coming and are still coming our way. So I'll pause there, Salil, keeping the time in mind. And yes, I hope I did answer the question that you had.
No, you have, but there were a couple of examples you were going to cite. Sure. And it might be a good time to, just in a couple of minutes, if you can tell them before I turn to Rohini, yeah. Because we may not get a chance to do that otherwise, so yeah.
Sure thing. I think I'll just take very quickly 2 examples. One of the first examples, and for good reason, was Telenor starting to support the Norwegian public health authorities in terms of using aggregated, anonymized movement patterns of people to trace and track how the pandemic could potentially move. This data and this data modeling was also then used as part of the EU Joint Research Center as early as first quarter of last year and helped tremendously the authorities in planning both the movement control orders, but also preparing for the health authorities to have beds available or staff available, basis what the pattern of movement of people would be. Now, this was slightly easier for us or our research team because they had in the past 4 years conducted research together with Harvard using aggregated anonymized telco movement data to track and trace the spread of dengue and malaria in Pakistan, Bangladesh, and Thailand. So we had experience of how this can be used by health authorities, and it can be overlaid over the health data, and that helped. I want to take another example, which I thought was very interesting for us in Asia, which was Malaysia and the Ministry of Health approaching the telcos in Malaysia, asking them to provide similar data, which was to track the movement of the population across the regions and the 2 islands of Malaysia. And what the telco regulator there facilitated was to form a joint task force with all the telco operators together. So we had data scientists and privacy experts from all the 3 telcos who helped model this data model, which was then used quite effectively by the Malaysian government for two things primarily. One was to check the efficacy of the movement control orders or the MCOs that have been issued in Malaysia. And the other was actually to check the spread of new clusters. And for folks on the call who would remember, as early as March, there was a Tabligh cluster which spread out the disease quite a bit in the country. But using this telco aggregated model helped a bit. So I think those were 2 interesting examples to show how telco data could help and has helped tracking and preventing the pandemic.
Yeah, no, it's fascinating, and to be in the position where you have to effectively play the role of realization of rights, and your role is actually to enable communication is very interesting. Rohini, I want to turn to you next because you have been engaged with this issue for quite some time now. You've been looking at technology and its impact on society. Who understands the issues deeply, and you have also written extensively on technology and its interface with society. In particular, you looked at apps from 11 countries for the report which we are publishing soon, in which you've looked at Asia Pacific and around the world about the kind of data protection measures being used, about the kind of technologies being deployed, and what are its likely impacts and where the weaknesses are. Can you just talk us through your key findings in a few minutes? I mean, we have 16 minutes left, so maybe over the next 6 or 7 minutes, yeah. And then I'll turn to questions, yeah.
Thank you, Salil. I seem to have a shaky connection, so I've switched off my video. Can you hear me clearly?
Very clearly.
All right, great. So for the forthcoming report, I studied 11 countries, out of which 4 are in the Asia Pacific: India, China, Taiwan, and Singapore. The previous speakers have already touched upon most of the things I'm going to speak about. I'll just give a summary of the findings of the report. So I found that different countries had deployed a range of technological interventions, which included hotspot mapping, which Manisha just described, tracking the movement of people, and to find COVID hotspots, which means places where there is a large concentration of people who are likely to be infected or people who are already known to be infected. The other purpose was quarantine management, keeping a track of quarantined persons and whether or not they are breaking any quarantine rules, for contact tracing, and for providing information, help, support, emergency services, etc., to people. All of these were deployed by governments, and the tech was developed by companies for the government under some sort of contract or arrangement. So apart from obtaining data from telcos themselves, obtaining information from telcos themselves, the apps and other software were developed by third-party companies for governments, and some of these technologies were implemented by the companies in public interest or for their own internal use. So the kind of interventions that were rolled out since the start of the pandemic were electronic taggers, so anklets or wristbands, which track the location of quarantined persons, and in some instances used for tracking movements, such as ensuring social distancing or hand washing practices, tracking the mobile phone location for quarantine management or hotspot mapping. So tracking the location of individual phones in different places. For hotspot mapping, it is some countries prefer to have anonymous aggregated data. Whereas for quarantine management, this is a very intrusive measure where they were trying to track the location of individual users who was supposed to be under quarantine, but the granularity of the geolocation of a mobile phone, which is obtained from mobile towers, does not particularly help in this respect to track where a certain person is going with their phones. Another intervention was video surveillance via camera networks, and these the surveillance was carried out via, in some cases, face recognition software and fever detection systems. So this infrastructure was already in place, where there are mass surveillance camera networks across the city or any other location, and they were already linked to face recognition software. So the claim is that they were checking if the people are wearing masks or if there is some, a quarantine person is out and about. And the other claim was that there is thermal imaging happening via the cameras, which will help with fever detection. And apps for quarantine management, contact tracing, providing information and services. Now, these apps had many of these apps had overarching permissions that were not necessary for the stated purpose of the app, which was either to make sure to figure out if someone had come in contact with a person who was likely to be infected, or to make sure that they were not breaking quarantine rules. And in the absence of a data protection law in some of these countries and specific privacy policies for the apps and other tech interventions, some of which are some of these technologies at the back end are technologies for controlling and preventing crime or other security threats. In light of these facts, the scope and opportunity for abuse is tremendous, and this is especially likely to affect vulnerable and at-risk populations and demographics. So data leaks have happened of both government-enforced technologies and company technologies, although I have not yet been able to establish a direct linkage and a conclusive linkage between a leak and abuse of this information. But there have been past precedents, as some of the other speakers have pointed out, that once these technologies are in place, A, they become permanent fixtures, and B, there is potential for abuse, whether or not we can establish a linkage between the presence and collection and storage of this data. So I will stop there so that we can have a bit of time for Nirosha and the audience.
Yeah, no, you raised some very profound issues, Rohini, and they go to the heart of this debate between privacy, but public good and private good, I mean, basically. And we have 10 minutes, so I'm going to now turn to Nirosha, who's a fellow, to make her intervention. And then if I'll see if there are questions in the chat, please post them now. If we don't have questions, then of course I have them. So I'll ask some questions to the panelists. But Nirosha, over to you.
Thank you so much giving opportunity to give some examples and experience we face in Sri Lanka. I'm a representative from Sri Lanka. Very interesting invention, and the things has already discussed by the many these people. And in the Sri Lankan context, actually, in the central government and the local governments has already taken some initiations, developing some applications in order to manage the COVID people and getting some informations related to them and providing some services. Actually, in the initial stage, right when the pandemic is starting in our university, Kotlava Defense University, in the students and the lecturers has already developed a system called Curate. So that is also actually what our people face. The problem is like in the very initial stage, when the data gathering and all to communicate with different stakeholders was a problem. Like it's very difficult to communicate with the other people, but anyway, so it was come to normal. And then after, we have many apps. Different local governments has developed many different small apps to collect some information and get to information about whether there are any COVID positive people in the nearby, like that. But there are some issues like keep on getting updated information, be a like problem like the people inform about that. And also that is about the application development in the Sri Lankan context. And another thing I want to highlight here is we felt another problem like in Sri Lanka. Actually, we had a central the database to update about the COVID-19 patient informations, but there was a problem like in the initial stage, the local government has already the information feeder to the systems, but unfortunately, some of the informations are missed. I mean, like somebody has changed those information, like, so that was a problem we face in the country. So actually, President also involved and question about that, that data protections. We have to concern about these data. When we develop sort of a common central data related to that, we have to keep the protect of these data and unauthorized access. We have to prevent the unauthorized access from these data. So that is a main problem we face in the country. I hope that it was okay, back to normal. That's all I want to discuss about from my side. Thank you so much for giving opportunity to talk in this forum.
Thank you. Thanks very much indeed. Yeah, I mean, the whole idea about maintenance and recording of data and how it is kept is crucial. I haven't seen any questions yet. So Graham, I still have a question for you though. We have about 6 minutes. So I'm going to ask one question each to all of you. And I think we will be, unless there are other questions that come in which case I will yield my floor to them. But Graham, I wanted to quiz you a bit on the sunset clause, and I didn't know much about the Australian system, but I was encouraged by what you talked about, the erasure and the fact that there is the provision of a kind of a sunset clause that, data will not be kept for a long time. So two things. One is that to what extent is it unique? And second is to what extent is it replicable? Can it be developed into a global standard? Do you think Australia is ahead of the curve of other countries, or it has a lot to learn from other countries? Graham?
Right. Yeah, I'm back on now. I don't think there's any reason for it to be unique, Salil. In the COVID Safe Act, the minister is supposed to declare when the utility of the app is finished, when it's no longer of any use. And then at that point, the whole system is legislatively required to be destroyed, and all retained data, equipment, everything. The problem is that there is no objective way to get the minister to make such a declaration.
Right.
In our view, there should be something like the Privacy Commissioner should be able to make an assessment and provide information to the minister, and trigger the minister making a declaration in that way. But that hasn't happened yet. But I think it could be an effective system generally in COVID legislation. The EU, however, has done a much blunter thing and simply provided in the regulation that establishes the COVID passport there that legislation terminates on the 1st of July next year, I think was the date. And so for it to continue, it would have to come back go through the European procedures for making new legislation with the checks and balances involved there. So, no, I think one way or another, sunset clauses are easy enough to devise.
Yeah, thank you so much. We have 3 minutes now, and I see that there's a question from Bong Bakalalad, and I'm going to read it out in the interest of time. My apologies, Bong, to any of the panelists, but I think it's appropriate for Manisha. We have focused too much on the surveillance aspect, but less on the human rights impact of where business could have had a role. And Manisha, you can look at it from both angles, positive and negative roles in this regard. I wish to hear about business getting involved and how. What are the proactive steps you think? I'm now paraphrasing and building on the question. What are the proactive steps you think can responsible companies take, bearing in mind the UN guiding principles and GNI, to play a more meaningful and constructive role?
Sure. Thanks, Bong and Salil, for that. I think the fundamental piece here is for businesses, and whether they're businesses who are developing these apps and technologies that we've all spoken about, whether these are businesses like ours, which are then facilitating these tracing, tracking, etc. Pieces, or businesses that are operating in geographies that are impacted with the health crisis and subsequent economic impact. The fundamental is to do a human rights impact assessment and figure out what it is that you can contribute to reduce that impact. And in terms of a proactive step or a more positive step, I think getting involved with other stakeholders, whether it's the authorities, whether it's the civil society, or it's the development sector in that market, to support where you can. So I think collaboration, as with everything else, is also key here. And we've seen businesses stepping up in pretty much most of the geographies that we've operated in, whether it is the old school philanthropy to actually coming up with technological solutions to support various impacts that the pandemic has raised, whether they're human rights impacts or economic impacts. So I think given that we have 45 seconds, I would say that the role the businesses play and have played and should play is to do an assessment and to collaborate in giving a positive impact or reducing the negative impacts of the pandemic. But back to you, Salil.
Yeah, and very unfair to you, Rohini. You have 24 seconds now to say, are you hopeful or are you a pessimist? Rohini.
I am hopeful. I just like to see impact assessments and independent third-party audits of this tech that is being rolled out.
I think that's a very cruel way to end the session, but it's a very, very important message that we really need proper impact assessments, and which are done consultatively in a participatory manner. I remember what Carl Bildt once said, that, you know, if you live in a democracy, you should not worry about surveillance, to which a friend of mine who was a human rights expert in India said, if you live in a democracy, you don't need surveillance. And I think we need to bear that in mind as we go forward. My apologies for the technical glitches we had. I'm glad you stayed through the end of the session, and hope you have a wonderful rest of the conference. Thank you, Graham. Thank you, Manisha. Thank you, Nirosha. And thank you, Rohini. Thank you very much.
Thanks
Thank
all.
you.
Thanks, Salil. Have a good day.
Have a good day.
Thank you.